it is imperative that you get those estoppels that you look through before saying, yeah, I'm willing to buy this property. So making sure that in advance, you're checking it out, you're seeing how much is owed, you're looking at any recorded liens, you're looking at the litigation that's opened up by those associations is so very important in preventing what can be a really expensive nightmare.
This episode brought to you by Suites at Madison. Meeting and conference rooms for rent by the hour, week, month, or year. Suites at Madison, where business gets done. Check them out at www.downtowntampaoffice.com. Now, on to the show.
You are listening to the Invest Florida Real Estate Show, covering topics in lending, buy and sell strategies, property management, hot markets, and tips and tools to guide you along the way on your path to real estate success. You want Florida investment real estate talk? You have come to the right place. And now, our hosts, Eric Odom and Steven Silverman.
Hello and welcome to another episode of the Invest Florida Real Estate Show. This is your co-host, Eric Odom, flying solo this week. Steven is out, but we'll be back for the next episode. Wanted to talk a little bit about reviews. And, you know, we guys, we do this podcast. It's a labor of love, but it does take a lot of time, and there is a lot of effort put in producing the show, trying to find guests that are valuable for you, the listeners, and hopefully you'll be able to get something out of it and advance your real estate career. We don't take any revenue off of this show. We don't do advertising. It's not about that for us. It really is about we originally started this as an encyclopedia for our clients because we kept getting the same questions about lending and buying and due diligence and you name it. People are asking us the same questions, and we would sit on the phone for half an hour explaining things to them. We were just explaining things over and over and over and over again. So, you know, that and also market. People were asking about what's going on with the market. Where's the market now? And so this podcast was a reaction for that. It was basically filling a need. People were asking the questions, and we started providing an encyclopedia of knowledge. And then we really, you know, when we got into it, we just kept going, and we enjoyed doing it. We don't ask for anything from you guys except if you have it to leave a review, because that review helps us. Our guests do go and look to see what our listeners are saying, or is anybody even paying attention? And so those reviews definitely help us to program the show, because people will go on and see that our listeners are engaged and they're the type of client that perhaps they might be interested in either dealing with or buying from or lending to, or whatever it is they're doing. I mean, everybody that comes on the show, they're all busy people, and it takes a lot of effort for us to schedule these folks and to convince them that their time coming on the show is valuable. So if you've not done so already, would really appreciate you going on to the Apple iTunes store or other reviews. It could be Stitcher and wherever, leaving us a review. Wanted to these reviews, we use something called a Chartable, which it puts all of the reviews together. And so we can go and look at whether it be iTunes or Facebook or whatever. We're able to, people who leave reviews, it sort of puts them all together in one place, so we're not having to go look at multiple different areas to get these reviews. But one just popped up from November of 2020, which we haven't read. We didn't see it before, but it's pretty unusual for us to wait so long to read a review. But this just popped up in our Chartable page. So sorry about not reading this earlier, but it looks like Louis Erks, Louis.erks.is from the Philippines, left us a review, 5 stars, and says, love how informative and fun all the episodes are. Well, Louis, we definitely appreciate you and the time that you spent to leave us a terrific review that does help us with guests. And if you haven't done so already, we really would appreciate if our other listeners who haven't done so to do the same. Wanted to get into our guest today. I'm pretty excited about who we're having. I originally heard her on someone else's podcast, and she's just a fountain of information, of knowledge. Natalia Ouellette. She graduated from Stetson University College of Law in May of 2009. She received her bachelor degree from the University of South Florida International Relations in December of 2008. She has a master's degree in business administration from the University of South Florida with concentrations in finance and international business. and that was in December of 2010. Natalia's practice focuses on helping real estate investors reclaim their time and their sanity with their contracts, leases, evictions, foreclosures, purchases, and tax deeds. Natalia's decade of experience participating in over 6,000 real estate closings, reviewing over 2,000 title policies, and representing real estate investors in over 1,900 cases makes her uniquely qualified to promote and defend investors' property rights. She has a book that's out. If you purchase Florida Tax Deeds, that's on Amazon. Tax Deeds, How to Become and Stay Wealthy by Mastering Liens, Possessions, and Marketability. And we consider it a must read for anybody considering investing in tax deeds and tax liens. Natalia, welcome to the show.
Thank you so much, Eric, for having me here.
No, I really appreciate you investing the time with us today. I think we came together originally because I had seen you doing another show, and I can't remember which one it was, but I was like, man, we need to get her on our show because she's so knowledgeable about tenant issues and landlord issues that I think she'd be able to offer a lot of very valuable advice for our listener base.
Well, thank you for thinking of me. I like to provide information to the real estate investor community in the entire state of Florida. I think it is part of a duty as a counselor at law to give good information and updates and to provide landlords and other types of real estate investors with the ability to make educated decisions about their investments and, make those decisions that are going to limit liability, limit litigation, and keep their investment secure.
And we're going to be talking in depth today about due diligence, but I'd like to first start so that listeners understand who you are. So maybe you can talk a little bit about law, how you decided on real estate, what your area of practice is. Is it, solely real estate? What type of real estate? Is it contractual? Are you doing closings, all that sort of thing? But first, let's just start with, how you decided on real estate.
So I've always been a lover of business, whether it was business law in law school or prior to that. I don't know. I've loved mathematics. I'm one of those weird, random lawyers that actually enjoys numbers and figures and calculations. And so real estate was a natural expression of having that kind of a mindset, that kind of a preference. Mm-hmm. And so when I was in undergrad, I did international relations, but my focus was always on how did it impact multinational corporations? So it was business oriented. And then when I went into law school, same thing. I took all the business classes, the tax courses, and it naturally just led into a lot of real estate transactions. So when I was in law school, I also worked on my MBA because I'm one of those weird nerds that likes to just endlessly learn. And my focus was on finance. And so when it comes to real estate and real estate law, it is all about teaching your clients to run their business, to look at it from not just the perspective of, is this going to get me sued, but how does this increase my profit margin? How do I mitigate costs? How do I expand my business? And so it just culminated in this natural realization that, oh my God, I love real estate law. I want to keep doing this. And I had the opportunity to get into the real estate business by becoming in-house counsel for a title company back in 2011. Shortly thereafter, I became the president of the title company, and I was involved in that for close to a decade. So with that experience, I also had my own firm in which we were doing the litigation to clear up title issues, the litigation to represent landlords when there were disputes taking place. So it's been about 12 years of hands-on experience with the legal side of it, but I would say close to 18 years of just really being enamored with the business world.
Talking about title work, we love, cloudy titles. I'm being facetious, that. But we just did we did a discussion on this not that long ago because we've actually had a couple of issues that have popped up. One of them, I think you and I discussed before the show about one of our clients who had borrowed money from a private money lender, and the private money lender completely, quote unquote, forgot that he was paid back some $350,000. And we had a document that had never been filed and, never been filed with the clerk of the court that says that he had paid it off. And the document was from 2007, I think, 2006, 2007. And now we're trying to sell that property for the client. What a mess. The lender's saying, no, I don't think he ever paid me back. I mean, it's not easy.
It is not, but that's where my years of experience and kind of sleuth ability comes in. It's certainly not for the faint of heart dealing with title transactions, because they do go back sometimes decades, sometimes centuries, and it takes some time to fix matters in which, there's did they get paid off or not? Or did this person actually intend to convey this 30-foot to their neighbor or not? Because they seem to have conveyed it to somebody else along the way too. Mm-hmm. The title clearing aspect of it. Like I said, not for the faint of heart, but I love it.
Well, why don't we talk a little bit about due diligence? Because this is a minefield for a lot of folks. Some of them, many investors, particularly newbies and even experienced folks, will get tripped up on some of these issues in the due diligence process. So why don't we talk a little bit about due diligence, both on the buyer side and on the tenant side?
Sure. So due diligence, a lot of people say, okay, well, what does that mean exactly? And it essentially means, are you doing your investigation of what you're getting into before getting into it, before putting up your money, your time, and your sanity in trying to acquire an investment property or in getting settled down with a specific tenant. So it's all about taking care of those things in advance and finding out what you need to find out. So I kind of wanted to discuss today with you, what are some of the things that you should be investigating so that you are really complying with it, what is necessary due diligence to protect yourself and protect your money and protect your time and what you want to do with your business. If you don't mind, could I go ahead and kind of cover a little bit about the sales process?
Of course. Yeah.
Okay. All right. So, when people go to buy investment property, and I kind of want to stick to investments because your community is the community of investors. They go into it, they find this property and they say, oh, I think this is a great deal. They're listing it for this price. The market's looking like this. Maybe they go look at the property. Maybe they see that it's rented. There's some tenants there, but, sometimes they don't go beyond that. That's very dangerous. They take a lot of things on faith with the rest of the parties that are involved in the transaction, be it the seller or the agents or the title company involved, but they really should do their own digging, or at least take advantage of the documents that are provided to them and the documents in the official record to see, where does the property truly stand. So some of the questions that investors should be asking themselves before really signing on the dotted line or getting involved in these transactions are, is the property truly marketable? What is making this property, this asset, such a great deal? And marketable talks about how willing is somebody to buy this property, and how likely is it that you could acquire this property via a warranty deed, meaning it's got the guarantees of title and possession, and no one's going to make these random claims and say, hey, I've had this lien on this property that nobody knew about, or hey, no, I have a superior interest in this property because, my Nana said that I inherited this building. So how much title cleanup is required to sell or to purchase this with a title insurance policy? That's something they should be asking themselves. And looking at a title commitment from a title company is a great way to get that information, to see, how deeply involved is this going to be? How long is it going to take to close on this transaction? I mean, there's a lot of things to clean up. It might take years sometimes for a transaction to close. And if it's truly nice, neat, and clean, it might only take a couple of weeks to make the acquisition. So it really is important that they take a look at those title commitments. Other things that are involved in due diligence are, aside from obviously going to see if the property is there, because sometimes people sign on the dotted line and they're like, great, it's building J, such a community, and that building burned down 10 years ago and there's nothing there. So they really should be going to see if what the structure supposedly is there is actually there. But I wanted to talk a little bit about like the as-is contracts versus the standard warranty contracts. A lot of investors make purchases based on as-is contracts. Mm-hmm. And with as-is, of course, you're kind of taking a risk of, like, what are the things that you don't see that might become really costly in the future? So the roof, the foundation, those kinds of things that are just suspect. Is there a sinkhole history on the property? Are there outstanding claims? Is there litigation going on for this because of some sort of a structural defect or damage? And you might not know about it if you don't ask. So it's really important that if you're a buyer, you ask those questions. They're hard questions. Don't just rely on like the written statements from sellers or realtors or title agents. Ask the tough questions because you're investing a lot of money, right? And then on the other hand, if you're a seller in an as-is transaction, don't just rely on the terms of the contract that say, okay, all right, as is, you're taking it the way it is, because it's not necessarily the case. There's a Florida Supreme Court decision from 1985, so it's long-standing, but few sellers understand what this means, and it's called Johnson v. Davis. And it's about fraudulent misrepresentation. So what that Florida Supreme Court decided is that sellers have a duty to disclose known material facts. And known material facts can range from, there's a leak here, to the pool pump doesn't work anymore, to, this building, has had a termite infestation. So those are all material facts. They might not be material to you as the seller, but they might be material to the buyer. If they were thinking, okay, I'm buying a condominium thing and it's got 10 units and it's actually only 8 units. That's a known material fact. And if you don't disclose that information, you could have a lawsuit slapped in front of you for Johnson v. Davis cause of action, even if you have an as-is contract. So it's really, really important that those questions get asked on both sides and that you just disclose what you know if you're a seller. And then the other thing that kind of is part of due diligence that people don't necessarily take into account is when you have those contracts in place, are you looking at the deadlines in your contract? And how are you calculating those deadlines? A lot of people say, okay, I start counting from that day and then I count, 20 days out if it says 20 days or 30 days out. But the other side might be starting the next day, mm-hmm. or they might start a day after that, depending on when something was submitted. So I always go with the most cautious date, count out starting from your day, count backward a couple of days and make that the deadline in your brain, so that you're always accomplishing whatever's required within the deadline, no matter who's counting. Because deadlines really can destroy a transaction. They can destroy a deal. And they're very, very important for terms like inspections, closing date, financing. So that's kind of the part of due diligence that I wanted to discuss with you regarding sales, because those little things can crawl up and become really expensive litigation for either side. And a lot of people don't think of it as due diligence because they think of did I look at the property as their due diligence aspect, or did I do my financials? But it's not necessarily just that to be comprehensive in your due diligence strategy.
Talk to us a little bit about, some of the key things, the key points. I mean, for us, we're seeing HOAs and tenants being probably the biggest deal if you're buying an investment property, particularly if you're buying a commercial property where tenants might have a 3 or 5 year lease and a lengthy relationship with the landlord. Sometimes they might have even promised that they would sell the building to the tenants. So talk a little bit about that, because we've seen some crazy stuff both from the HOA side and from the tenant side.
Yes. Yeah. So that's kind of the other side of due diligence. It's truly important when you're doing acquisitions of investment properties is looking at your estoppels. And so you've got kind of like 3 estoppels that you should be really focusing on. Mortgages, obviously, if you've got payoffs, you just want to make sure that you've got the payoff dates right. You got to take into account about how long it takes to get a payoff. They have generally up to 14 days. Is there any like pending litigation? Are there any like hidden fees, corporate advances, yada, yada, that are going to get tacked on if you don't pay by a certain date? But truly, the lease estoppels and the association estoppels are so important to observe. Associations are renowned for changing their estoppels the moment that like the deadline expires. So they're very strict with their deadlines. Unlike mortgages, for example, which have like per diem calculations that you can just tack on if you're off by a few days in sending the payoff. With associations, if the payoff isn't received by the specific date that they provided in their estoppel, you can foresee maybe hundreds, if not thousands of dollars more in attorney's fees just for preparing a new estoppel. Mm-hmm. All of a sudden, there's violations that weren't there before. There might be litigation. They might have recorded a lien during that time period because they didn't get payment. So you really need to be looking at like, when it's good through, what are the repairs or violations that have been listed? Have there been any noise complaints, for example, listed regarding tenants? That's a big one that can lead to litigation from your neighbors or penalties and assessments made against you, the future owner. So really something to consider in terms of like due diligence. Look at those estoppels, thoroughly review them, particularly from associations. And if there's things that are just like off, they just seem very off. So they're like, well, the mailboxes are not compliant because of blah, 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 but they look exactly like all the other ones. You might want to bring that up with the association before, again, signing on the dotted line and being like, oh yeah, I'm willing to take on all this. I'm fine with it. With leases are such complex agreements between parties. And like you said, they're long-term agreements between parties. So it's very essential that you have in your hand when you're purchasing property that's subject to a lease or several lease agreements, that you have something that it summarizes the most important terms of the transaction. Those are often referred to as abstracts. But you need to have something that will explain to you, not just the names and addresses and contact information for the tenants, but, what is the rent? Are there right of first refusal? Are they allowed to make expansions? Are they allowed to make modifications? Has there been any amendment in the type of rent? What are the late fees? When does rent come due? A lot of people assume that it's the first of the month, but there are leases that start the 5th of the month, the 8th of the month, the 15th of the month. And so for notice purposes, those are super important deadlines to know. And an abstract can truly summarize that and provide like a 1 to 2 page at a glance to let you know, okay, this is what I'm getting myself into. These are the deadlines that I'm going to need to know to deal with tenant A, tenant B, tenant C, tenant D, without having to yourself review 20, 30, 40, 50 page lease agreements. And the longer ones generally are the ones that are for commercial purposes. But once you're getting into multifamily, those are sometimes considered commercial types of leases. Mm-hmm. So it's really important to look at that because that'll let you know, okay, how many of these units are delinquent? How difficult is it going to be for me to capture a good return on my investment if half of these units are in delinquency or half of them have a terrible payment history, late payments, or how many of those have had waivers in terms of the late fees that are supposed to be collected, how many of them have not been notified properly of their non-renewal and they're working under an expired lease that's now become month to month. What are the deposits? Just because you've got commercial lease agreements or multifamily unit agreements doesn't necessarily mean that people have put down deposits.
Deposits are such a big thing. I can tell you that, particularly a lot of these mom and pop buildings that we deal with, the landlord goes, I never took deposits from anybody. They sound like a good person. And you go talk to half the tenants go, oh yeah, I gave them a deposit.
Yep. Yep.
Let's talk about that. Like, you have a situation with a deposit where the tenant says he paid and the landlord says they didn't. And how are you going to deal with that? Who's responsible? The buyer says, well, that was an agreement between the two of them. And no, it's not. I mean, not necessarily. You're buying that. You're assuming that lease. You're also assuming the liability of that lease.
Correct.
If the guy does produce a canceled check from his bank that he gave a deposit, you got to know that, or you're going to end up holding the bag.
That's correct. And it happens fairly frequently. I see in too many closing transactions where people are acquiring properties that are, subject to the tenants and they're transferring the leases, that they do not have a proper accounting of those deposits, of the last month's rent. There's just... People take too many things at faith. And the problem is when there's oral agreements or improper accounting or improper tracking of these transactions in court, that can create prolonged and costly litigation, because the moment that you have to have evidentiary hearings, mini trials, or full-blown trials, you're talking tens of thousands of dollars in litigation fees for something that could have been solved with a few minutes of due diligence, or at least you could have made yourself aware, okay, like this one's going to be problematic. Let's get this resolved now before I sign on the dotted line and take on this burden. Those can be very, very costly. And that's why those abstracts and summaries, however you want to call it, are so important to have. You are assuming the responsibility of whatever agreement went on between the parties, whether written or oral. And so learning what those responsibilities and agreements were beforehand are absolutely essential.
No doubt. I mean, you've got the leases, you've got the HOA, and the lender. You're wanting to make sure all those things are buttoned up. And I can tell you from anecdotally and from a working perspective, typically those are with the tenants. It's some of the last pieces of information that you get, because typically the seller does not want you interfering with their tenant until which time they're pretty certain that the deal is going to go through. So I know we structure a lot of our due diligence periods where if for the seller, we're trying to protect the landlord and say, you have to do that first stage, which is structural, and what might be bank and title and some of these other issues up on the front end. But after you've completed those and you've signed off and you're good, then we'll let you talk to the tenants. But many times the buyers will just skip that part and they'll look at the lease and assume whatever's in the lease is what it is. And man, you can't do that. You talk about doing the abstract, just do it as easy as putting together an estoppel letter from the abstract saying, this is what the lease says. Please sign here to confirm that you're in agreement with what the lease says. There's no deposit, that there's no outstanding, there's no commitment of a sale to you. But those are some, we've purchased buildings for clients where 3 people have said, oh yeah, the owner sent me an email and said he'd be happy to give me a right of first refusal. Well, gosh, that just came out of the blue. You got 3 fires you're trying to put out.
Yeah, and people don't think about it, but it could be something as simple as, oh no, well, they told me that I could park this type of vehicle here. Or no, we have an agreement that says that, I can use that trash receptacle that's in the building next door that's also owned by your seller. And those are not written, but they are agreements and they are enforceable so long as there's some sort of consideration involved. Yeah. And if you don't know about it, you are in a losing position, because you're either going to look like an idiot if you decide that, no, like this is wrong, it should be litigated. And after the fact, it's going to be difficult to find that seller and get confirmation. And the more the time passes, the more that people forget the specifics of what was agreed, if it's something orally, right? Yeah,
and the estoppel washes that stuff. The estoppel, look, you have that open-ended question, and there basically says, there's nothing else besides what's in this lease that's sort of that catch-all that affects what you're paying or what you're doing or how you're managing this. And if they sign off on it and say, yeah, that's it's all accurate, then they're going to have to be, if they're saying, hey, we can use that receptacle, we can park this truck, and then realizing that they can't, now they're in a position of weakness from a litigation standpoint.
Correct, because that agreement then becomes something that supersedes any prior agreements, wipes out any ambiguity, and puts it in favor of what's written down as the official terms that are going on between the parties, between landlord and tenant. So yes, having those estoppel agreements, having them sign, yes, this is it, this is it, this is what my deposit amount is, or I have no deposit, or I've never put down last month's rent, is extremely important for people that are going to be acquiring these investment properties. But it's also as equally important in having those things written down, in making sure that you're asking the right questions in those estoppels. So are you asking about who are the occupants? Who are the authorized occupants? Who are the tenants? Who are the parties that are perceived to be truly the tenants that have an enforceable monetary agreement to pay this rent? Are there any other adults that are allowed to be on this property? Are there supposed to be any other adults allowed on this property? Or if you have commercial property, typical thing that happens, let's say business A is the one that enters into the lease agreement, and then business A's owner decides they're going to create a little side business, call it company A 2.0 or A sub, right? And are they allowed to be conducting their business and then transactions from there? Are they considered a tenant at that point? Is it a violation subleasing kind of an agreement that they're running a separate business out of it? So you really do need to have this clear, because the consequences of allowing certain businesses can truly destroy your lease agreement. I'll give you an example. So let's say I decide to buy a commercial building, and it's a professional building, right? So I have an accountant, I have a real estate lawyer, I have a tax lawyer, I have a title company, etc. And let's say the tax lawyer decides that they are going to now open up a little sub-branch where they're going to be practicing real estate law. And you already have a real estate attorney in there. And that real estate attorney in their lease says, if you have somebody that's competing with me here, right? I have an exclusive right to be the sole real estate attorney here. And if you have somebody competing with me here, I can get them out of my lease. You have the potential of losing a 5 years worth of income if one of your current tenants decides, I'm just going to expand my practice into this, or I'm going to create my little side business of this kind of law and run it from here. So that's also why those abstracts are really important, not just in right of first refusal, but are there any exclusivity points in those agreements? Mm-hmm.
Yeah, no doubt. And let's talk a little bit about the homeowners and the community associations, because that's another one of those issues where we see inside of community associations, organizations that a lot of people don't realize that there's community organizations where even with single family homes, and it might be a landscaping agreement. Well, guess what? They've not paid their dues for months. The person buys a single family home, or it doesn't even have to be a single family home. We see this in industrial parks too. Didn't realize that they were part of an association. Well, yeah, they're part of the association, and now they have not paid for the landscaping and the association dues for months, if not years. And then the owner buys and gets this nice little notice, say, hey, well, thank goodness you're here now. We were suing the previous owner. Here, write a check because this is what you owe us. And then plus attorney's fees that we were litigating this guy. You owe us $20,000. That's a day you'll never forget. So how do you protect yourself?
Yeah, that's that joint and several liability provision that's in pretty much every association statute in the state of Florida, which says, hey, if you're the new owner, you are now jointly and severably liable with the prior owner for what was owed and assessed against this particular unit or sets of units, right, if you buy more than one. Mm-hmm. And it can be quite costly. The attorney's fees in the community association industry are not very well regulated, and it is very, very expensive to challenge them. So you can definitely foresee thousands and thousands of dollars for something that could have been a very simple, easy to take care of, like violation where there was a stain in the driveway. Or maybe you accidentally forgot to mow your lawn for 4 weeks because you were on vacation or you hurt your back. So yes, it is imperative that you get those estoppels, that you look through before, saying, yeah, I'm willing to buy this property, because it can be extremely expensive. And one of the misconceptions that buyers have is that they can then, and this is something that happens, like, let's say foreclosure buyers, but I can expand it out. It is very difficult to go back and file suit against the prior owner and collect for that difference that they paid up. Even though there's like joint and several liability, it is just incredibly hard to squeeze money out of a dried up turnip. And so at that point, trying to collect your funds from the prior owner, who's really the one responsible for what happened and all those fees and costs and attorney things accruing. So making sure that in advance, you're checking it out, you're seeing how much is owed, you're looking at any recorded liens, you're looking at the litigation that's opened up by those associations. Is so very important in preventing what can be a really expensive nightmare.
And this is another thing I want to talk to you about too, and I'm going to say the listeners understand this. I personally, in another life, was responsible for oversight of litigation at our firm, and able to check boxes and know what cases were outstanding and where they were, and sort of pushing it through the attorney. I'm not an attorney. I was sort of the quarterback that was overseeing those things. So when someone says to me, oh, I'm not really worried about those things, if there's some big issue, I'll litigate, that's somebody who doesn't know what the hell they're doing. I'm sorry.
Yeah.
It's one of your worst nightmares to be involved in litigation. You want to avoid it at any possible way, because nobody wins from it except for the attorneys. And sometimes even the attorneys don't win from it, because somebody ends up defaulting on them and they get stiff too. So it's not really a path, a strategy for solving these issues. It's the last thing you want to do. Sometimes you have to. Sometimes you got no choice.
Last resort. Mm-hmm.
Yeah.
Mm-hmm.
Yeah. I mean, Kenny Rogers used to.
I could not agree with you more.
used to sing a song about that, where essentially about a kid who was constantly picked on, and there was a reason why he didn't fight. It wasn't because he was a coward. It was because he understood what it meant to be in a fight. And so this is the same thing with litigation. It's not a 6-month process. It's not a 3-month process. It's years. The process is years. And the other side, even if they know they're in the wrong, is going to stomp in the mud hole until they make it as clear as mud, probably where the term came from, that the judge or a jury or no one else can really understand what's going on. So they'll just split the difference and say, okay, well, you both are responsible, or maybe you should be on the winning side, but you're going to be on the losing side, because the mud hole is, or the water hole is now a mud hole, and nobody can really understand all the facts because the other side has successfully dirtied the visibility. And that's what people need to understand.
Yeah, and not only that, but just the exhaustion that is involved in litigation.
It's a job.
It's not just, because it's not just money. People that haven't been in litigation before don't understand the stress, the lack of sleep, the way that it consumes the parties while litigation is pending, particularly if it's very fact-based. Litigation that is, involves like, here's what the law says, and, it's not truly adversarial. It's fairly simple. And even then, that can take about a year. But if you're talking fact-based, there's discovery, there's depositions, there's interrogatories. And for every single one of those things, you've got court reporters and other fees and expenses involved. There's details you've got to constantly remember. There's summaries to prepare, experts that get involved. And that takes a huge emotional toll on parties that they cannot begin to understand.
No. And they want your emails. We all have things in our emails that you do not want made public. And if those emails become public, all of a sudden there's a cudgel to use against you. And what was very clear path of some injustice being against you, now you're a bad guy because they're going to read these emails and they're going to twist and they're going to distort them until you look like a guy who potentially could not be trusted. And that's what they're trying to do. And these are the things that people don't, but if they haven't been involved in litigation, they don't understand. And then when they have done one of them and it's 3, 4, 5 years down the road, and as you say, lost sleep and, God forbid it ends up in a public dispute where only one bit of that, information is getting out, and now you're painted as this horrible person. It's just not something you want to do. You can trust me on this.
Yeah. And with civil litigation, it's not subject to the protections in terms of like, what are the contents of what's being disputed. It's not as protected as, for example, family law or probate litigation. With civil disputes, it's pretty open. A lot of people can go into the public records, make copies, and see all of the dirty laundry that took place between these parties. And also the types of cases will kind of expand that stressor depending on the type of dispute. So, for example, like landlord-tenancy disputes, those are actions at law, and actions at law can have juries. So, having everything aired out in front of a group of 6 to 12 people that can now become public record. Now you have like news agencies that are involved. This is being published. You get painted as this horrible landlord, blah, blah, blah. You definitely don't have to deal with that. But, so few people put in their leases, no jury trial. At the same time, or they just have an oral lease agreement, which is the worst thing you could possibly do.
Oh, yeah.
The other type of cases, like if you have title litigation, those kind of things, those are actions in equity, and those generally the arbiter of facts is a judge, and those are generally not subject to jury trials. But even then, do you want a judge to see you in that way? Because that judge might be the one deciding your next case, and you want to be in a good position with them, and you want to be seen as the person that acts in good faith. So yeah, those communications that you have, with the other parties involved in a transaction need to be respectful and clean and all of that. But people forget. People don't think about it that way. They, life gets in the way, and it can really impact the success and merits of your case. So being proactive about things, being preventative about things, doing your due diligence, and just doing as much as possible to limit litigation is truly the key in being successful.
Yeah, no doubt.
In like I said, not just your business, but in your mental health.
So Natalia, we've talked about pre-qualification of buyers and tenants. We've talked about estoppels. We covered some bit about leases in terms of making sure you get that sort of an abbreviated abstract, some bullet points to cover the things. But we've not talked a lot about items inside of a lease that you want to look for, because you've checked all these other boxes here. We've done on the due diligence. We've talked about the engineering aspect, the structural aspect of it, making sure that the survey's accurate, the title's accurate. We've talked about all those things, but now let's talk a little bit about the leases, because you really want to just study those leases for tripping points. So what are some of those sort of missing terms, or maybe terms inside of a lease that you think are pretty common that could trip up a buyer?
So some of the terms that, like missing terms, and what I mean by that is like if it's something that's left out, it's going to be ambiguous. It's going to just open you right up to litigation. And that's, like I said, the last thing you want to deal with. So terms that should be included in leases, and I'm going to discuss a little bit about the residential type leases. You need to have clauses about pets, and not just like, oh, you can have pets, but how many pets? What kinds of pets? They need to comply with what your association or, the community requirements are for pets. What happens if that pet passes away? Do you need a new pet addendum if that pet is replaced? Weight of the pets, the bite history of the pets, for example, or the scratch history of the pets. And I'm not just talking about dogs, but birds and cats and lizards, snakes, all of that. You need to be really specific in those pet addendums. And I find that a lot of people are missing them. And then they come to me saying, well, they have a pet and I don't like it, and they're destroying all this. And I'm like, did you have any contents of your lease, discussing the ability to have pets or not? Well, no, yada, yada. So it's like, oh, now it's ample for litigation. Smoking, that's a big one. And with the passage of legislation that permits medical marijuana use, you want to be really clear about who can use cannabis products on the property, where on the property they can be used. Treated similarly to nicotine. Can it be done? If so, where? What needs to be done for cleanup purposes? Who can be around it? How is it stored? Really protect yourself, because you do not want to, you don't want to be the subject of a criminal investigation. Utilities is another big term that people forget to discuss. Who's taking care of what? When does that start? Water, electric, gas, trash pickup. Depending on the county, trash has to be contracted for or not. It could be included as part of the standard water usage thing. So that's something that really needs to be put in clearly, because you don't want to have a tenant that you're trying to evict go, oh, well, they were supposed to take care of the trash and they didn't do it, so that's why I offset my rent. And now it's a motion to determine rent, and it delayed your eviction by 6 months because of that. So really important to put those in nice and clear. Parking, that was something that I brought up. What kind of vehicles could be parked there? You might be in a neighborhood where you can't park commercial type vehicles. And so you should be asking your tenant, what do you drive? What do you use for work? They might not qualify as a good tenant for you if you live in a community where they restrict the type of vehicles to solely, private use, non-business type of a vehicle. Termination. I have seen too many leases that have no termination terms. Nothing. Not how it's noticed, not when it ends, not what are the causes that lead to terminate, not what happens if the tenant wants to terminate the lease early, nothing. And it really is such an important term, particularly in the era of COVID, where you don't want a lease that just automatically keeps renewing endlessly. That is going to, subject you in essence to being stuck, unable to get rid of a tenant that's not compliant, and give them an opportunity to present something like a CDC affidavit and prolong their stay while you're just incurring losses indefinitely. So having termination clauses are really important. Maintenance, really good standards for who does what kind of costs are tenants allowed to incur themselves and offset you for, if at all. How do you get notices for maintenance? And you want to create a standard practice and procedure that you require every time there's something that needs to be repaired. How do they notify you? There's a lot of tenants out there that are using management systems that notify them in writing, of what's going on. And that's such a great way of tracking, maintenance requests. So I encourage any landlord out there to get one of those programs, one of those systems in place, and make sure they're getting these requests in writing and acting upon them quickly. They have 7 days in Florida to get those repairs done. And then rules and regulations. I strongly recommend to all of my landlords, create rules and regulations for living in your property. Cleanup, mowing, how frequently should it be done? Noise. You don't want to be the subject person who gets the noise ordinance violation, slap and fine and penalty, because your tenants like partying at 11 o'clock, or they like arguing at 2 o'clock in the morning, and their neighbors are just being driven nuts. And most municipalities have noise ordinances that can result in fines and penalties. So you want to make sure that you're very clear with your tenants about that too. Occupants. Right. So your lease terms need to say who's an occupant. Too many leases just say, hey, this is my tenant. And they don't talk about their family members or who's allowed to be there, who's not allowed to be there. And you might have somebody's new boyfriend come, and now they move in and they're not your tenant, but, them and your tenant have a fight, and they want them out and they refuse to leave. And now what do you file against them? They're not your tenant, right? So these are important things to have in your leases. And then I find that all too often they're missing as terms. They really should be discussed.
Yeah. I mean, in commercial leases is you've got the personal guarantee too. Are the guarantor's even alive still? These are some things we've run into.
Yeah. Yeah. I mean, with your commercial leases, when you're thinking of your terms, you want to make sure, like, is this a net lease? Is this, like, what kind of net lease is it? Are they having to pay the property taxes, insurance, maintenance on the property? Guarantees. If somebody is doing a personal guarantee on a commercial property, what kind of due diligence are you doing to verify that they qualify to guarantee this lease? Have you looked at their income? Have you looked at their investment portfolio? How do you know this person can really satisfy as a guarantor if there's a default on this lease? There's just too many people going, I had them sign a guarantee. And I'm like, what do you know about them? Do you have their social security number? Do you have any information on them? No, I have nothing. It's troubling because it's like, well, you've got a pretty worthless piece of paper then. It's called a commercial guarantee, but again, trying to enforce a judgment against somebody on collectible is going to be really, really tough. Commercial leases should, include like signage. What are they allowed to post? What would be like a violation of like a local ordinance with signage? Same thing regarding parking. Say you're leasing like a mechanic business, where can they put those cars that they're repairing? Are they allowed to put them in the front area of the property? Are they required to put them in the back area? What other kinds of vehicles are they allowed to bring in? Those can all result in, again, fines, penalties, assessments by the city or the county against you as the owner. And so you want to make sure it really can be done in the commercial premises and what can't be. And where you can, those things are not also really important terms, because if they can shrink the premises, well, if you're doing a per square footage rent, all of a sudden your rental income is going to be, or has the probability of being less. So those are terms that need to be clearly delineated, examined, and looked at as part of like the due diligence when you're renewing leases, creating leases, or assuming leases.
Yeah, and conforming use is one of those items that buyers get nipped in and tenants too, in the rear end all the time. It's, in fact, I'm just tell a little anecdotal story about, there was a hair salon that had been in a property on Kennedy Boulevard for years. And next door was like a CPA, and the hair salon, it's a retail space, it's zone retail, and it's not a problem. But with personal service, there's a heightened parking requirement. And so, yes, you can put your business in there, but you got to have the parking places for that type of business. And it was fine if you were a furniture store, but for personal services, I think I want to say the numbers are like, depending on what it is, and restaurants can be as high as 15 parking places per 1,000 square feet. So it can be, very, very onerous to be able to meet the standards of a conforming use. Well, next door was a CPA. He didn't care. He retired, and it was him and his assistant, and had a handful of other, clients who occasionally would come in, but there wasn't a stream of people. Who bought his building was an attorney, and the attorney had three associates and their paralegals and a receptionist. So a big change in the number of people who were in that office. And then all of a sudden, the hair salon parking spilling over into their parking lot, which had been going on for years, all of a sudden was a problem. And the attorney had a conversation with him and said, you can't park here. And it went on for a couple of months, and then he just basically reported them to the city for non-conforming use, and they basically kicked him out of there. So these are things like, and then all of a sudden the landlord's stuck with an empty building that they're trying to that's built out for a hair salon, very expensive build out because of all the plumbing.
Right.
Now he's got to reverse it, and was an expense that he never expected to have. He's got to cap all the plumbing in the floor, and now he's got to open it up, and now he's got to try to rent it to a 3,000 square foot space to a furniture store or whoever else might be able to fit in that space that has a lesser parking requirement, and it's not easy.
It's certainly not. And that's, one of the reasons why, if you're investing in commercial real estate, you need to have a land use and zoning attorney, or, somebody that is a specialist in knowing exactly what that kind of, let's say, little plaza, et cetera, requires, whether compliance requirements by the city or the county, if it's, located outside of a municipality. What do you need for the type of business that you're thinking of putting in there as a tenant, or that's currently there as a tenant? Are there any current violations based on the type of business? Yeah, absolutely essential to have those people on your team for commercial transactions.
Yeah.
And again, too few people do it. They rush into it, and the result is costly.
Yeah, the cost can be very, very high. And you want to try to rework a building. Lumber now, buying sheets of half-inch plywood right now at $80-something a sheet that used to cost $20-something a sheet. And all of a sudden, you got a $100,000 conversion cost that you didn't expect when you were buying the property. That's a pretty bitter pill to swallow.
Oh, very.
Yeah. So, hey, Natalia, this has been terrific. Some really great information here. If folks want to get in touch with you to discuss whether it be some contract, or maybe you want some, to help them with some due diligence, or anything else to do with the law around real estate, how would they go about reaching you?
So the easiest way to reach our office is 813-480-2106. or 813-480-2309. We have a dedicated line 24/7. Somebody is going to answer the phone, take your message, relay it back to us, and we get back to people within 24 business hours. There's also the other easy way to contact me is by sending an email to my legal admin. So that would be legaladmin@lcolawfl.com. If you have general questions, frequently asked questions about investing in the business, like I said, we have a YouTube page that's just filled with information, kind of like you have the wonderful podcast here. There are 3 to 5 minute videos on all sorts of topics in real estate investing. And that one, you just Google my name or YouTube my name up, Natalia Ouellette, and you'll find our page. And that's how you can get a hold of us. Our information's plastered all over that page as well.
Yeah, and let me add, Natalia has been all over from the COVID period. I started following her. As I said, I listened to her on someone else's discussion. I believe it was on YouTube. But I started looking her up, and she's been all over all these landlord issues as it relates to COVID, and telling the investors and the landlords what they can and they can't do, and explaining to them what the difference between the local ordinance and eviction ordinance are versus the national ordinances, and what can and can't be done. And she's just been a wealth of information and knowledge for the investor class. So hopefully you guys got a lot out of listening to her today, but she is somebody definitely you should put on your speed dial, or at least save her information on your favorites on your browser, so that you can go back there and look and get pinged when she's got information coming out, because she does produce a tremendous amount of very valuable information for landlords and investors, and I think you'll be able to get a lot out of what she's posting out there, because she's definitely directed at you.
Well, thank you. I appreciate that shout out, and you as well. I mean, the value that you provide in your podcast is just wonderful. And these are really in-depth conversations that you're having. So I strongly recommend that if somebody has a daily commute, they put on your podcast. They're brilliant.
Thank you so much, Natalia. I really, really appreciate it. And that was Natalia Ouellette talking about due diligence on real estate. And I wasn't kidding. She does produce a tremendous amount of information for investors. I think that you would do yourself a service by seeking her out, finding her YouTube channel and her blog. We also she posts on the Invest Florida discussion board on Facebook, and she'll put stuff on there. So you can, if you're already a member of our Facebook page, our discussion page, you can just add notifications and get pinged. She posts at least once a week information that's relevant and timely, and definitely somebody worth keeping in touch with and following what she's working on, because she likes to study, she likes to learn, and she likes to share that information. So, guys, as always, we appreciate the time that you invest with us each and every episode. We'd encourage you to go to our website at www.investfloridashow.com for other great guests just like Natalia. And until next time, hasta la vista.
You've just listened to the Invest Florida podcast with Eric Odom and Steven Silverman. Join us every week for actionable real estate investment ideas, and of course, visit our website at www.investfloridashow.com for more shows and tips on how to earn a cash flow in the real estate market in Florida. While hosts and producers of the Invest Florida show have no reason to doubt the validity of comments of our guests, we do not warranty their accuracy. Please check with your legal, financial, and tax advisors before entering into any investment. Returns will vary from person to person and deal to deal based on unique circumstances. All information expressed in this show is for educational purposes only. Opinions of the guests are not necessarily shared by the hosts and producers of the Invest Florida show.